Welcome to Business Auto Focus on Liability Part 4. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar via email. If you experience any auto problems, please send us a note in the chat window or call our office at 800-741-4084. We'll attempt to correct the problem as soon as possible. Let's look at what we've done in the first 3 hours. The previous sessions addressed the importance of making sure you list the correct named insured. You got to find out and list the business whose assets the business auto policy are going to protect in item 1 of the deck. Any legal entity listed in the item 1 will meet the definition of you in the coverage form. It could be a corporation, LLC, partnership. Legal entities of the business. If it's could also be a proprietor if it's not incorporated. However, there's no need to list the owners, partners, managers of these legal entities in item 1 of the deck sheet, of course, unless it is an individual, a proprietorship. Second, we must understand what's a covered auto. To have the policy respond, the auto that was involved in the accident must meet the definition of covered auto, or the policy will not respond. Who it will respond to is anyone who qualifies as an insured in the who's insured provision. You, that's the legal entity listed on item 1 of the deck, but only for the covered auto. Any permissive user, anyone who operates a covered auto with permission from the you, the entity on the deck sheet. Customers and owners of legal entities, anyone listed for the conduct of an insured is an insured for that for their vicarious liability exposure. That's blanket additional insured, but not the owners of the covered auto. The insured, the you, has coverage, but not the owners without an endorsement. So if you schedule an vehicle that's not owned by an insured in item 3, you would need to add, if it's owned by the owner of the legal entity other than an individual, C9917, employee as lessor. If it's long-term finance lease, it would be additional insured lessor and loss payee, which is CA201. Or if it's owner-operator, we typically use CA9916 if it's scheduled on the policy. Protection for your insured arising out of their auto exposure is addressed by the use of the auto coverage form, because if the insured gets sued, they expect their insurance policy and agent to provide them protection from these suits. The trigger of coverage being provided correctly to always meet the insured's expectations. The liability policy will respond if the insurance applies. If not, then it's excluded. So the exclusions to watch and make sure there's coverage, and other than the auto liability form of the insured have the exposure. Again, contractual, it's broad form contractual, except for railroad and trucking agreements. We need to make sure that there's work comp coverage to make sure all the employees are covered under comp, so the employees cannot sue under tort. That's the advantage of work comp, is tort immunity. If there's no coverage in an employee, then there's no coverage in the policy. Work comp pays. That's concerned here. We have to worry about the care, custom control. They're usually typical 2 items, and it could be an insurer's care, custom control. For our trucker, it could be their cargo, or if they're a private carrier, it also could be their cargo, the thing they're hauling, delivering, that would require a cargo policy to buy back that exposure. Or if it's a vehicle that is not owned by the insurer, they hire, lease, rent, or borrow, then you have non-owned auto physical damage. And lastly, the pollution exposure. The pollution done by cargo, there's no coverage. There is coverage of the fluids or others' properties that make the vehicle go, or someone else's property caused the pollution loss. There is coverage, but not if the insurance cargo. And this is an endorsement that you buy that back, CA9948. We went through in detail how the auto policy and GL policy works together, particularly in the loading and unloading. If your insured has any responsibility for loading and unloading, whether they own the vehicle and it's their property or not, you need to make sure they have a GL policy to protect them while they are loading and unloading the unit. Or if they use any mobile equipment, forklifts, front-end loaders, or cranes, you also need a GL policy. Or after they finish the movement of the property from the vehicle to its final destination and do not then secure the gate, stack the beer, stack the blocks properly, and the horse comes out of the gate, the blocks fall down, the beer fall down, again, there's no complete operation. That would shift to the general liability policy. So it's very important to have the auto liability and the general liability with the same carrier if all possible because of these gray areas. Let's look at some other considerations. I get asked often, how much limits do I need? My pat answer to them is, tell me how much damage you're doing and we'll discuss what the limits you need. I actually had one agent one time when I was setting up requirements of my insured to use subcontractors, that subcontractor had $500,000 worth of coverage. The agent came back and said, oh, they only need $300,000. What the agent was interpreting is that's all the state required the vehicle to have. My answer back to her is, how do you know what they need? Because you don't know how much damage is done. So setting the limits is very important. Also a function of how much assets the insured has. And those are usually public assets. In other words, when a crash happens, it's bad enough. The plaintiff's attorneys make policy limits demand, and they have to make a choice. If the insurance carrier decides to or is willing to pay the policy limits, the plaintiff attorney has a choice to accept those limits or keep pursuing the insured, which would have to be paid out of the insured's pocket. If they could go online or a web page and find out they own a lot of property, a lot of vehicles, a big operation, a franchise, then clearly there's more exposure, and for bad damage cases, the plaintiff's attorney might say, no, the insured has assets. Therefore, we're not going to accept the policy limit. They could be exposed for more than that. Well, again, here it depends on how high that policy limit is to give the plaintiff's attorney the incentive to pursue the individual directly. If the policy gets settled within the limits, then the insured gets a release for the payment of the policy limits or the payment by the policy up to the limits. So this is a consideration that we have to think about when we talk to an insured about how much the limits they have, and it depends on how much assets they have exposed to in that business. If they have a lot of goodwill, if they have a franchise, then you would need to increase their limits even higher, and you would do that by writing an excess policy. The auto policy that you deliver says, regardless of the number of covered autos, insureds, premium paid, claims made, or vehicles involved in the accident, the most will pay for the total of all damages and covered cost of expense combined resulting from any one accident is the limit of insurance for the covered auto liability shown in the declaration. So the limit is all that will pay. Now, the defense of the insured is in addition to the limit. The reconstruction of the accident site is in addition to the limit. This is just the damage that's paid to the third party. And so again, how much assets the insured is attempting to protect, how much public their information is on the assets they own will determine how they need your discussion with them on the limits they possibly need. All bodily injury, property damage, and covered cost of expense resulting from a continuous or repeated exposure for subsequently substantially the same conditions will be considered as a result from one accident. Again, this is up to interpretation. There's been a lot of interpretations where when something falls off of a vehicle, the falling off is an occurrence that could hit something, but if it bounces off and hits another vehicle, is that two occurrence or one occurrence? Some of us remember the 9/11 World Trade Center discussion, a lot of paper discussion about that, whether that was two occurrences or one occurrence. It's very important to determine that, but we really can't determine that until you're fact-driven, and lawyers and plaintiffs' attorneys will argue about this. Again, we need to make sure we have a high enough limit to protect the insured's exposure. No one will be entitled to receive duplicate payments from the same element of loss under the coverage form, and any medical payments coverage endorsement, uninsured coverage endorsement, or underinsured coverage endorsement attached to the policy. So again, you only can collect one time. So if you get offsetting things that will provide insurance coverage, again, work comp can even be added to this, then you can't collect it on auto liability. Again, the injuries to employees are excluded, so it would have to be some other kind of situation that you would have to be involved in there, but those are the kind of things that you cannot collect twice on. So the limits. Each accident has full limits, no aggregate, unlike GL. But multi-injuries or multi-covered auto does not increase the limit. So again, you have to give the insured guidance as to the limits they might. Don't ever set the limits, just give them guidance and let them know what their exposure could be, because autos can hurt people. Unfortunately, we've seen too many of those. Other than insurance. This is also extremely important. This is in the back of the policy and the policy conditions, item 5. For any covered auto you own, those are covered autos that the insured owns a title to, or if listed in the schedule and added one of the endorsements that we just talked about, the CA 9947, the CA 201, or CA 9916, which converts those non-owned autos to an owned auto, the coverage form provides primary insurance, meaning that the coverage form that covers that auto, that's a covered auto owned, steps up and defends on a primary basis, defends anyone who qualifies as an insured in the policy, which would include the permissive user and the customer, on a primary basis. So that the coverage is primary if the accident and the claim is caused by a owned auto, whether either because it's in the title of the insured or because we add one endorsements which converts the non-owned auto to an owned auto. For any covered auto you don't own, the insurance provided by this coverage form is excess over any other collectible insurance. So in the case where your insured is a contractor, your insured hires a dump truck to haul dirt on their behalf, that dump truck operator has a crash, that dump truck operator's policy would have to step up and protect the dump operator on a primary basis, protect the driver and protect your contractor as long as he or she's being held liable for the actions or the conduct of the driver. If that policy on the dump truck that was hauling the aggregate to your insured's job site does not settle the case, then their own auto policy would step in and be in excess of the policy on the vehicle that caused the crash, where they were covered under the vicarious wording in that policy. So any owned autos is primary, any non-owned autos would be excess, except for trailers. However, while covered autos, which is a trailer, is connected to another auto, the covered auto liability coverage this coverage form provides for the trailer is excess when it's connected to the motor vehicle you do not own, and primary was connected to a covered auto you own. I've always said here that the trailer coverage tracks the power unit. So what it says here is that if you're insured, loans somebody a trailer, gives somebody a trailer, leases somebody a trailer, and an accident happens, your insured is covered by the policy on the vehicle that the trailer is attached to, and they're on a primary basis. Again, defense and payment and release. The policy that you would have covered under the policy of your insured would be excess of that. If your insured borrows someone else's trailer, puts a lease trailer or borrowed trailer on their power unit, and a crash happens, then the coverage for that trailer attached to an owned power unit, the coverage would be primary. So that's just how it works. Owned autos is primary, non-owned is excess, and trailers track the power unit. MedPay. This is an endorsement we can add. It pays reasonable expense incurred for necessary medical and funeral expenses caused by an accident for up to 3 years. So this is sometimes called voluntary MedPay. How this basically works is that if something happens at the site and there needs to be reasonable medical and funeral expenses caused by the accident, meaning ambulance called up, x-ray, medical attention, or again even death, in these here, then that is paid irrespective of the liability. We only pay under liability when insured is negligence. MedPay pays even when there is no negligence. The theory behind this is if you take care of the smaller claims, then the claimant might not seek more than just those small payments and not sue. Unfortunately, I wish that would work. And being inundated by all the lawyers' advertisements that we hear on the radio all the time encourage them to step up and call a lawyer to sue. I'm not sure that that theory that it reduces claims, reduces tort liability claims actually works. But anyway, it is available. It pays you, family members, or occupants of covered auto, but here's the problem. It does not pay injuries to an employee. So the value of MedPay, or even to offer MedPay, would depend on who's in your insured's vehicles. If it's a larger vehicle, if it's a vehicle that is designed under federal regulation where an occupant, the way in the vehicle can be an employee other than without the written permission of the insured, or if the insured has no rider's policy on vehicles and large vehicles here, all the occupants of those vehicles would be an employee. So therefore, MedPay wouldn't pay, even though it's there. That's why MedPay is so cheap on larger trucks. It won't ever have to pay. So why would you provide auto MedPay on a commercial auto policy? Again, if there's a private passenger auto on it, yeah, you could have guests in there, and that could be concerned, and going back to dissuading them from suing on a tort would be the effect there. But if it's only large units used in business, then you would not have a need, in my opinion, to provide MedPay if the policy is only the employees there. But what happens to non-employee? Well, you got to remember, this is volunteer MedPay. If the non-employee in the vehicle, even though it's there, we don't want them there, it does happen. They can still sue under tort, under negligence. So you're really not taking anything away from the insured by not having MedPay, because they still have protection of the policy. What I'm trying to point out here is it doesn't benefit most of the large commercial auto users, because you will not have an opportunity for it to be, for any payment to be made, because what we have in a vehicle is employees only. So this is when you make a discussion, and you might think that $10 or $15 might not be a consideration overall, but when you think about it and you're up against an agent who understands this, and you offer MedPay, and that other agent asks you the question, why did you do that? And you don't have a good answer, that just puts a wedge between you and the insured. So you need to understand this. When MedPay pays, when it doesn't pay, the benefit of MedPay. And in larger commercial auto usage, it's my thought that MedPay is not something you'd want to provide. The next subject would be uninsured motorist or uninsured motorist. First and foremost, you must provide information to the insured so that they clearly know their options and can make an informed decision. In this decision, you must offer bodily injury policy limits and show the cost of the uninsured motorist or uninsured motorist at those policy limits. So every state allows the insured to select, or most every state. There's a couple that do not allow that, a couple like New Hampshire that just makes policy limits, period, for MedPay or uninsured underinsured or uninsured or underinsured motorists. But in states where there is an election, the election gives the insured a chance to usually select three things. The policy limits, or four things really. The policy limit, or they can reject, or they can select stacked or unstacked limits. So the rejection form says, here is the limit you can select, and again, it must be, in my opinion, offered at policy limit with a cost, and then the lower limits. Some states have a minimum. Other states, the insured can reject all uninsured motorists, and then they can choose to stack or non-stack. Stacked or non-stacked means that if an auto accident happens and there's a crash to the auto accident, the occupant of that vehicle that's entitled to uninsured motorist coverage collects the coverage on that vehicle. That's unstacked. If it's stacked, then they can take all vehicles covered in the policy and add all that together to the vehicle, to the coverage on the policy, on the vehicle that was involved in the crash. Typically, we sell unstacked. That's more definitive here. But now let's explain to the insured. Maybe we need to let them know how this works, and in most cases, the insured who has a larger number of vehicles, typically with only employees occupying those vehicles and having work comp in place. Most of those insured, if explained properly, probably would not want to select uninsured motorist coverage unless they have to a certain minimum limit. Again, you got to offer, but then explain to them. So we're dealing with commercial businesses here, use of autos. The occupants in those vehicles should be an employee. Again, I say should. I know there's cases where they're not, but the whole concept of this is it's commercial auto used for businesses. The employees are in the vehicles, and everyone in the vehicle is an employee. So the business's obligation for injuries to employees for job-related injury, and that's what auto crash is work comp. So work comp's the sole remedy. The only obligation to the employee in that auto that has an auto crash is work comp. There's no other obligations for the injury worker. That, again, is the sole remedy. UM and IUM is not a benefit to the employee. Work comp is the sole obligation. So that is an optional. That's a benefit like health insurance and anything else, because now the employee can collect more than comp. If the employee is concerned with job-related injuries and their use of their employees' autos, they can purchase uninsured motorists or underinsured motorists on their own personal auto policy. This is the same for any non-employee. So you must offer this option and have the insured make a business decision that is best for their business. Here's a suggestion discussion. Insured, if your employee is injured in an auto accident while working for you, they will collect work comp benefits. This is your obligation to your employee for a job-related injury. If the injury is caused by a not-at-fault accident, meaning someone else hurt you or insured and the other party was at fault, then your employee can collect for work comp, but they also can sue the at-fault party for their injuries. Your work comp carrier could get some protection in that suit because they will get some payment back again where the benefit to the insured, they can't collect twice for the same damages. And in that case, then you remind the insured, if this happens, uninsured motorist or uninsured motorist is an option for you to pay or to you purchase. And the key to that word is you purchase, because your uninsured or uninsured motorist steps in and protects your insurance as if your policy covered the vehicle that caused the accident up to the limits you choose. So it's going to cost you money. And if an uninsured or uninsured motorist happens, then it's going to be reflected on your loss runs, which gives your underwriters a dilemma, because now they've got to decide, well, really your insured wasn't at fault, but the crash happens, we had to pay something, so do we really count that against the insured or not? I will tell you the mentality of most underwriters, and if you're in their position you can't blame them, the answer is yes, we got to get something for that. After all, we paid $500,000. So you got something you purchased that you didn't have to purchase as the employer, as the insured on my business auto policy. That cost you money. If you ever have to pay out on that, then it also gets your loss run. You do not have to provide it because you have work comp. And by the way, your employee can purchase uninsured or uninsured motorists on their own personal auto policy. So do you want to pay me to add coverage to your policy that you're not legally obligated to pay, to have, when you have work comp in place, that if you do and have a crash, it's going to an accident where your driver gets injured and caused by a not at fault driver, then that will go get your loss runs. And by the way, that employee can cover themselves if they're interested. So do you want to pay me something that would affect your loss runs that the employee can buy for themselves? Most of my insureds say no when it's explained that way. In fact, I developed a long time ago a part of the employment packet that spells this out. The law requires the employer to carry work comp insurance. This is a part of the packet where the employer and the employee signs together. Damage to employees due to work-related injuries. Your employer carries this insurance to meet their obligation to their employees. Your employees are your employee has elected not to carry uninsured motorist coverage on its automobiles. This insurance is designed to pay for damage sustained in an auto accident caused by an at-fault underinsured motorist. Your employer has met their obligation to their employees in this instance by providing work comp coverage. If you feel you want protection beyond work comp, then you may purchase coverage or on your own personal auto policy. You should contact your insurance agent for his or her guidance. Then you'll understand, I understand my employer does not carry uninsured motorists on the vehicles, and you have the employee sign it. And then you date it. That's a part of the employment file. I've used this for a number of years, and in most cases, the insured selects to reject. So you need to offer, you need to advise them on the selection process. You need to then talk to them how it works, and then let them make the option. All the court cases that I have seen where you had to pay uninsured motorists after the fact is when the insurer did not make the right the informed selection, and that's the key. And now informing the employee about it will also be a part of the process. I've had a number of times where I've been challenged by a plaintiff's attorney. I send them this form. I hear nothing else from them. Now, this is absolutely opposite of personal auto. Personal auto, I would never write unless uninsured or uninsured motorist meets the policy of personal auto. But we've got to remember, we're shifting now from the personal activity of somebody to a work-related situation. And in a work-related situation, the occupants of the vehicles will be employees in most cases. Again, depends on your insured, and this is where we're talking about. And those employees are going to be covered by work comp. So therefore, your employer, who is the employer who is the insured in this case, is meeting their obligations to injuries to their employees in a job-related auto accident through the work comp mechanism. For a business, the auto liability coverage form provides them protection for their business assets if an auto they operate has an accident and damages the public. The policy will defend the actions of the operator and will pay for damage done by the auto due to the negligent actions of the operator if the party involved in the accident qualifies as insured, and if the auto that caused the accident is a covered auto, and if there is enough limits of coverage. So this is where we are as we look at the policy. It's the business exposure where they hurt the public. The injuries to employees are not covered. Those are covered by work comp. The policy will defend the actions of the operator. Anyone held is liable for the actions of the operator, and will pay for damage done by the auto due to the negligent actions of the operator, and will get releases for anyone who is involved in the accidents that qualifies as insured. If the auto that caused the accident is a covered auto, and again, if there's enough limits. So that's summarization of where we've been to this point. But let's talk about the federal requirement. We have insureds, and a lot of insureds as a part of the agents who are part of the members of the foundation deal with vehicles that are involved in interstate commerce. And so let's look at the requirement for the interstate commerce dealing at the federal level. The reason I point this out in the business auto area, because a lot of them are mistaken. The federal definition of a motor carrier who must meet the federal requirements to operate interstate is anyone using a vehicle for commercial purposes in interstate commerce that has a GVW of 10,001 pounds or larger. It's not an 18-wheeler. It's not the tractor trailers you see on the highway. It's a unit with 6 tires, either on the power unit itself, which is a dualies in the back, a 350 Ford, a 35 series Chevrolet, a 350 series Chevrolet, or a power unit with 4 wheels and a trailer. That's 10,000 GVW. It's not the larger 18-wheelers. It's your contractor. It's your lawn maintenance company. It's your welding shop. It's your newspaper delivery or the bread and cookie deliveries that you have, the step vans with these vehicles. If they cross state lines for business purposes and a vehicle is this size, then they must register, whether they're hauling their own goods or somebody else's goods. They must register with the Federal Motor Carriers Association and get a federal DOT number, and then pay a fee into the Uniform Carrier Registration System and make the responsibilities of the Uniform Registration System. This is the concern that you have, and also subject to all the safety regs and rules. So the government regulation, they must gain permission from the government to operate interstate. Who? Motor carrier, any user, any business of auto in interstate commerce, 10,000 GVW or larger, for hire and private, everybody. They must register. Anyone, private or for hire, that uses an auto with 6 wheels must obtain a federal DOT number. Some states also require those, and then they must obtain the URS through the government portal. That's how you get the register and get the DOT number. They must pay a fee. DOT holders with interstate units must comply with the Uniform Carrier Registration System. That's the fee basis. For 2 units, it's $76. For over 1,000 units, it's $76,000. If the unit is 10,000 GVW or larger, using interstate commerce, they must also conform with the International Fuel Tax Agreement and the National Registration Plan. Those 2 plans are a tax distribution system where the plans are based not on where the insured purchases fuel or purchases license plates, but the states the insured travels in. So if the International Fuel Tax Agreement requires the insured to report quarterly all the miles they travel in all states with interstate licensed vehicles and the amount of fuel they purchase, and that report then allows the mechanism to adjust the taxes in the fuel by various states and give every state the appropriate taxes as if the insured purchased it in that state, even though they didn't. The National Registration Plan, you look at the truck, front of the truck, and it's an apportioned tag. And that, again, the tax fees, or the license plate fees, which is tags, are based on not where the state the license fee was purchased in, but the state they travel in. And then as you renew your license plate, the insured renews the license plate, they tell the states how many miles this unit will travel annually and then how many miles in each state. And then the fees collected will be based on the percentage of time in each state. Again, this is for hire and private. That's the point here. It's just not 18-wheelers in this case, or is this not your for-hire trucker, even your private truckers? We do have a size difference. The DOT required number is any vehicle with 6 tires, but these are passenger tires. These are small trucks. These are the dualies. The 26,001 is a larger truck. Their tires are big truck tires with 1020s. Again, only 6 tires, but in that case, and so they must meet that. In some cases, they must prove of financial responsibility. If hauling processed goods of others, interstate commerce, that's your typical for-hire trucker. They must have an MC number and must have proof of financial responsibility. However, that MC number is going away, and the DOT number at the end of this year will be the only identifier. You also have the Motor Carriers Act of 80, and that requires a special endorsement of the policy, and that's an MCS 90. And that applies to all for-hire interstate and certain private hazards or hauling anything hazardous, any quantity across state lines must meet the requirements of MCIEF 90. And after September 30th, 2016, there must be an insurance filing for these risks. So here are the responsibility as a part of the Motor Carriers Act of 80. This subpart applies to for-hire motor carriers operating motor vehicles transporting property, interstate or foreign commerce. They must meet the minimum levels of responsibility. This subpart also applies to motor carriers operating motor vehicles transporting hazardous material, hazardous substance, or hazardous waste in interstate or foreign commerce. Those are your private. So you have the for-hire. The minimum limit for for-hire, if it's not hazardous, is $750,000. If you fall under provision 2 and that motor carrier is hauling something hazardous, if they're for-hire, that then would require $1 million or $5 million. If you're private, you have no requirement unless you're hauling something hazardous. So if you're insured crosses state lines in the vehicle 10,001 GVW and hauls nothing hazardous, they have to meet no requirement other than the state requirement they're licensed in. However, if they haul anything hazardous across state lines, then they must have at least $1 million or $5 million, depending on the hazardous nature of the product. So this is the requirement. The only exceptions to this is the size of the vehicle. If the vehicle has 10,000 is less than 10,000 GVW, meaning has 4 wheels, not 6 wheels, then they're exempt to this unless they're hauling poisonous gas or Class A or B explosives. So if you're insured crosses state lines with a vehicle that's a pickup truck, and that pickup truck is not hauling poisonous gas or explosives, then they don't have to meet any requirement. So it's the size of the vehicle, and 10,000 GVW, 4 wheels versus 6 wheels. This doesn't apply until there is 6 wheels. And the other provision is that if they cross state lines with any commodity, they must have this requirement. And what is added to the policy is an requirement, and that is an MCIEF 90 endorsement. That's an endorsement to the policy that meets the requirements of the Motor Carriers Act of 80. It says here in that endorsement, consideration of the premium stated in the policy to which this endorsement is attached, the insurer, the company agrees to pay. No defense, just pay within the limits of this endorsement described here in any final judgment. There's no defense. They don't do anything as a final judgment. Recovered against the insured for public liability. Public liability is defined as bodily injury, property damage, and environmental protection. This gets back to the requirement of the pollution coverage of the policy that we addressed earlier. Resulting from the negligent operation and maintenance and the use of a motor vehicle subject to the act we just had. That's any vehicle 10,000 GVW or larger, use in interstate commerce, hauling any property in state commerce if for hire, and private if they're hauling anything hazardous, 1 can of paint. Regardless of whether or not the vehicle is specifically described in the policy. This is where the gap of coverage is more often. Your insured fails to tell you about the vehicle. The insured uses the vehicle. They have a crash. The policy does not respond because it's not a covered auto, because if we use symbol 7 that requires it to be scheduled, it's not a newly acquired, it's not temporary substitute, and we don't have hired car, so therefore there's no coverage in the policy. What this says is that after the insured has a final judgment rendered against them because of their negligent operation of that vehicle, and nobody pays that judgment, then that plaintiff can go to the insurance carrier and say, honor their promise to protect the public in the Motor Carriers Act of 80. And this is the danger, and this is what steps in. Such insurance as is afforded for public liability does not apply to injuries to the death of an insurance employee, so it does not apply to an employee. This is what happens when you have the vehicles of that size, and this is important. And most of the vehicles that we deal with the foundation fall in this class. But the problem is some people call this insurance. It's not insurance. The purpose of this endorsement is to protect the public to a minimum limit. The reason it's not insurance is a further part of this endorsement. It says it is understood and agreed. Who understands and agreed? The insured and the insured or. That no conditions, provisions, stipulations, or limitations contained in the policy, this endorsement or any other endorsement therein, or violates therefore, shall relieve the company from liability or from the payment of any final judgment within the limits of the liability herein described. So the insurance company has to pay even though the policy does not. But it then goes on, however, all terms, conditions, and limitations in the policy which endorsement is attached shall remain in full force and effect as binding between the insured and the insurance company. So the first paragraph says, as far as protecting the public, the judgment against the insured, the insurance carrier has to pay. But however, the condition of the policy, vehicle to be specified, any kind of radius limitations in the policy, misrepresentation and fraud, no cooperation, anything that is involved that would have sometimes given the insurer or an opportunity, even driver exclusions, that would have given the insurer an opportunity not to pay, is still binding. Even though they have to protect the public, there's no coverage in the policy to the insured because the second paragraph is the insured and the insurer. To which this endorsement is attached shall remain in full force and effect as binding between the insured and the insurance company. And then the insured agrees to reimburse the company for any payment made by the company on account of any accident, claim, or suit involved a breach of the terms of the policy, and for any payment that the company would not have been obligated to make under the provisions of the policy except for the agreement contained herein. So what this says is public has to be protected for any vehicle the insured uses if they're for hire, if they're hauling anything interstate, and the property's interstate for hire, the public must be protected even though the vehicle is not a covered auto or there's provisions of the policies that are not, that would relieve the insurance carrier from having to pay. If it's a private carrier and the vehicle is 10,000 GVW or larger and it crosses state lines and the private carrier is hauling things hazardous, then this endorsement must be attached, and then that insurance company has the same obligation to pay. So it's both for hire and private. For hire is any property, no matter if it's cucumbers or pickles, no matter if it's corn or corn flakes, as long as that property is interstate commerce. The endorsement must be added to the policy, and the insurance company has to pay even though there is not a covered auto or there's other reasons that could be involved that would get the insurance carrier out of it. If it's a private carrier, meaning hauling their own goods, carrying their own items, and they cross state lines and they're hauling nothing hazardous, then they do not have to meet any requirements other than the state requirements for the size of the vehicle. However, if they're hauling anything hazardous, 1 can of paint, and they cross state lines with that 1 can of paint, then they must have this endorsement on the policy under the federal law, and they must, the insurance company then must respond just like it was for hire to pay on behalf of the insured, even though there's no coverage in the policy, any final judgment, not pay on behalf of the excuse me, to pay the plaintiffs any final judgment, even, and the insured reimburses them. And so this is nothing but a payment plan. Example, I know we're talking about, let's say if you have an insured who's a lawn maintenance company, they have 6 wheels, they cross state lines with 1 weed eater, then they would have to have an MCIEF 9 on the policy and would respond and would have to have at least $1 million worth of coverage because that's what it's going to require. This is what we're talking about. The limits required here, again, if it's a non-hazardous item and it's for hire, is $750,000. If it's a hot item, it requires $5 million. Your insureds are not going to inadvertently pick up something that requires $5 million because the shipper of those are going to make sure that your insured has the proper coverage. However, the provision 3 here, that's $1 million. If it's anything hazardous, and that includes gasoline, that includes the gasoline in cars if your insureds are hauling cars, like a record company or towing cars or those items, then that requires $1 million worth of coverage. If they're hauling poisonous gas and or explosive, that's any size vehicle, even the ones less than 10,000 VW, and that requires the $5 million. So this is the limits required. Why this is important is there's a major move under commercial auto that will be affected starting September 30th, 2016. That's the Uniform Registration System. The MC numbers will go away. The for-hire interstate hauling processed goods and interstate commerce, the DOT number will be the only identifier. The MC number, 10,001 GVW units, interstate commerce, will go away. The motor carrier with a vehicle, that's the motor carrier with a vehicle 10,000 GVW larger, interstate commerce, will only have a DOT number. That any insurer that needs a MCS 9 endorsement, the one we just went through, will have to have an insurance filing. So that is for-hire exempt. Who's a for-hire exempt? Well, it could be a cattle hauler, someone hauling pigs, someone hauling grain from Illinois to the ethanol plants in Iowa, somebody hauling watermelons out of Florida for consumption up the road during the watermelon season, people hauling tomatoes out of the farm plants to the processing plants. If they cross state lines, today they do not have to have a filing because those items are exempt from government regulation. And after September 30th, 2016, then that insured will have to have a filing of at least $750. If they haul something hazardous, then it would be, if they're a private carrier and hauling something hazardous, then they would have to have an insurance filing. Today, the only time the limits are enforced is when a DOT officer comes, knocks on your insurance door, and says, I'm here to help you. And so, and if they don't meet the requirement, today they can be fined $11,000 a day. Under the new system, the trucker could have to operate, but now the DOT officer is going to see as they run down the highway if they've met this requirement or not. And if they haven't met the requirement, they're going to stop them and put them out of service. And so now the penalty is they can't operate anymore without the proper coverage versus being fined upon inspection. There's also a new application that has to be done online through a portal. That's the MCSA-1, and that's also new. That was effective December 12, 2015. The reason this is important for business auto users is now there's a number of business auto users who will be subject to this new requirement of having a DOT number and having to have a filing. This is going to be increased enforcement, and we need to be aware as we look at providing auto liability insurance for these private users who are insured by business autos. If they have vehicles that have 6 tires on them and across state lines, then they fall under this new, they fall under increased enforcement and the more policing other requirement for financial responsibility. So what does all this mean? If it's the true trucker, they're using 18-wheelers. If they have an MC number, that's the motor carrier number, that's called a docket number now, and insurance filing, nothing. They don't change anything. The only thing they have to do is update their information on the federal webpage, which is done now by the Form 150. They must do it every 2 years, and they would update now using the new portal and the new MCSA-1. When your insured has to update this federal information is based on the last 2 digits of the DOT number. The second one from the end is the year. The last one is the month. So if your insured's DOT number ends in 52, then they'll have to update every odd year, every February odd year. If it's 010, 0 being October, not 10, excuse me, 08, 0 being October, and then it would, excuse me, I can't even do this. It would be 80. 8 would be every even year, 0 would be October. So it's the second one from the end is the year, even or odd. The end is the month. October being 0, and nobody has to update November and December. If they don't update, they will be put out of service for not meeting the requirement of updating the information every 2 years. If there's no MC number, but they do have a federal DOT number, they're for how? In other words, an exempt hauler will have to have a filing. They also have to have a processing agent. That's the BOC03. And a processing agent is an agent that's recognized, or the agent's required in every state the insured operates in, because the system recognizes that if an insured who's an interstate trucker means that typically or often they'll be domiciled in a state that's not the state where the accident happens, and they damage the citizens of the state, even though their insured is not domiciled there, there needs to be a mechanism for the citizens in that state through their lawyer to file legal papers on behalf of the insured without having to go to the insured's home state. So the insured selects a service, a processing agent, and that processing agent system has a list of people in every state that will accept legal documents on behalf of your insured for the crashes that happen outside of their home state. Filings can be started being made in September 30th, 2016, and they'll be based on the DOT number. The enforcement of both the filing and the BOC3s, the processing agent, will be effective December 31st, 2016, or January 1st, 2017 is when all this will start, and the government will start enforcing these rules. This is the implementation of the uniform registration system. Again, the 1212 date, which is the new portal for new DOT number MC, that's the Motor Carriers Act of 1980, will be for the new number that's active now. I've actually gone in there and obtained a DOT number, and I've gone through those screens and there's far more information, particularly about the insured than was previously required under 150, particularly trying to get rid of what we have in our industry called chameleon carriers, and that's an insured who's wiping out bad past history by reinventing themselves under another DOT number. The new application under perjury statements saying that this is subject to perjury acts if you lie about this, about your past ownership or management of a motor carrier previous. That must be divulged. That's the big difference. After September 3rd, 2016, then the update must be done through the portal. The DOT number will be the only identifier. MC number going away. There'll be a new fee schedule. It'll cost you $300 now for exempt and the private here for the filing, where before it did not require, it was only people with MC numbers that required that. This is the evidence of financial responsibility can start being made based on the DOT number. This will be new private hazmat, any quantity, and exempt for hire can start having filings made September 30th, 2016. Let me remind you, you all are insuring risks today that will have to have a filing very shortly. You also have to have a processing agent by that date. Then the evidence of financial responsibility in the filings for existing private hazmat exempt for haulers again, and the processing agent will be enforced December 31st, 2016. This is the new regulations being come in now, and this again affects every business that's using a vehicle, even though written on commercial auto policy, 10,001 GVW or larger. The last thing I want to talk about in this part is that the insured has the policy is enforced, and the main reason the insured uses the policy is protect their assets, or if the government makes them, like the filings we went through, or in some states proof of financials to buy tax. But that's really, they hope they never have a crash, and once they get involved in the legal, meaning the license plate financial responsibility requirement has been met, or the federal that we just talked to has been met, they're real used to it so they can do business with their customers. So one of the main reasons a motor carrier or a business purchases insurance is to meet their customers' requirements. Typically, customers require $1 million auto liability, $1 million / $2 million general liability, cargo if it's for hire, work comp to protect the driver. Additionally, the customer must be added as additional insured. The hold harmless agreement must be insured. There must be a waiver subrogation, and coverage must be primary and non-contributory with a 30-day notice of cancellation. That's typical. We're only going to discuss in this section here, because we're dealing with auto liability, how your auto liability policy reacts to these customers' requirements. What you have to do, what agents have to do, is provide a certificate of insurance on behalf of the insured to their customer so that the insurer can still do business with that customer. A lot of times the insured, the insurance proof is dependent on them continuing doing business with that customer. And a lot of businesses will shut a provider of service, a contractor, a delivery company, a dump truck operator, a for-hire trucker, anybody who deals with customers will not be able to deal with those customers without proof of coverage. So we have a limit of $1 million. The customer has to be additionally insured. There must be a whole harmless agreement that honors the whole harmless agreement in the contract. There must be a waiver of subrogation, and the coverage must be on a primary and non-contributory basis. That's what it requires. So you are sitting here as an insurance provider and have the request for the insured to send the certificate out. Now, how does the policy that you just delivered as a business auto policy cover these items? Cancellation. The first name insured shown in the deck may cancel the policy by mailing delivery on written notice only. So the policy conditions, only person we have to send notice of cancellation to is the first name insured. So the certificate says we have to send it to whoever, to the certificate holder, but the policy condition does not make us do this. So you have to determine that obligation. Transfer of rights and duties under the policy. Your rights and duties under this policy may not be transferred without written consent except in the case of death of an individual named insured. So those things can't be transferred either. So the waiver of subrogation is honored as long as you can, in the contract, you can waive your subrogation as long as you do it before the crash. There's a waiver of subrogation endorsement that you can add to the policy, the ISO endorsement here that honors that waiver of subrogation so that the insured does not, the insurance company cannot seek reimbursement on behalf of the the insurance company for the fault person named here, which would be the customers. Insured contract. Again, as we went through our program, if you remember, the definition of insured contract is broad form, so it's a whole harmless agreement. So the whole harmless agreement would be an insured contract, even if the insured holds the customer harmless for the customer's negligence. The liability policy provided by ISO builds in the form protection of the customer when the customer are held liable for the negligence of the motor carrier. That's anyone liable with the conduct of the insured. That's in the who's insured provision. We went through it in hour 2. That is built into the policy. Therefore, all customers are already additionally insured. There's no additional coverage you can add by adding the endorsement, designated insured endorsement, or any other. So all customers are protected. So protection provided to the customer under the policy form is primary and non-contributory. The reason it's primary is it's an owned auto. And because, so the customer's insured on a primary basis because they're owned auto. The auto that your insured is using, running down the highway, gets in a crash, the customer gets named. It's an owned auto to your insured, so the coverage is possible. The customer qualifies as an insured under the policy because of the who's insured provision. So the customer's coverage for defense and payment is on a primary basis because it's caused by an owned auto by your insured. The customer's policy will be excess of any coverage there, and you cannot seek contribution from anyone who qualifies as insured. So the insurance company cannot seek contribution from the customer, which is a misnomer anyway, because really the contribution is, in most cases, in the court cases that we're familiar with, not from the customer, but from the customer insurance carrier. So in this case, there would be no contribution because the customer's insurance policy would be in excess because it's a non-owned auto. So the policy we issue to the insured cannot be any more primary than they already are, and the customers are not cannot be seeking, you cannot seek contribution from the customer's insurance company. So the point here is when we have those requirements, as the other insurance provision that we just went through earlier in this presentation, when we have these requirements are already in place without any endorsements. So the owners of the business cannot seek contribution from the customer because the customer is an insured, and the customer probably would be in excess of coverage on your policy, on the insurance policy. So the auto liability policy covers the businesses with auto exposure. If it's the insured's property name, if it's a covered auto, for the damage done by a covered auto that's negligent damage to the public, it protects the insured, the driver, and the customers on a primary basis and meets the requirements of the customers of the insurer to do business with without an endorsement. We hope you learned something from these 4 hours. We look forward to seeing you in further CE programs.